Hello, everyone. Yolanda here, and welcome to the conversation. This is a very, very special episode that we had to definitely make sure that we had tonight. Yesterday was very heavy for many of us, and really the whole week, quite frankly, has been very heavy for many of us in just terms of dealing with what is happening and what has been happening in our country as far as racial justice, as far as social justice, particularly in wake of the Breonna Taylor indictments that came down, and especially in wake of the recent passing of Justice Ruth Bader Ginsburg on Friday. And so when a number of you all had reached out about, just general discussions in terms of understanding what happened in the decision, as far as some indictments being entered and others not in the Breonna Taylor case, and especially what that means in terms of where we are taking part and parcel with what has happened with the settlement and what that means as far as any justice for Breonna Taylor, true justice for her family. So tonight's show is a continuation of the indictment series that we had several. We had a series of 7 shows, if you were tuning in at that point, and we were taking a closer look at the criminal justice system. Had to bring it back very specifically for this one, because what I want to focus on tonight is to not only just talk about these 2 issues, but give you an opportunity to chime in, to ask questions, so that we can really talk about it as a community in terms of what has happened, what we can expect in the coming weeks, particularly as we are 40 days before the election, and what we can expect and do in the meantime and beyond that. So this is the 8th segment of the indictment series, and I'm calling this particular episode Justice Denied. Justice denied as it relates to the Breonna Taylor case, and justice denied as it relates to Justice Ruth Bader Ginsburg's final wish was that her seat not be filled by anyone other than the next president of the United States. So if you are tuning in, whether it's through the watch party or whether it's through the YouTube channel, make sure, of course, as always, before we get started, that you like, follow, and subscribe at all things at the Convo Pod Show. If you've not already done so, make sure that you subscribe to the YouTube channel. Make sure you follow the Instagram page and Twitter page, and of course, like the Facebook page. And if you've missed any of our previous episodes, all of those are listed not only just on the YouTube channel, but they're also listed on the Facebook page as well. We'll be resuming the Evolution series next week, but we really need to talk about what's happened in the last few days. And honestly, I think it's important for us to be able to have that conversation where we can have real talk about what's happened and what all that means. So my special guest is no stranger to the show. One of my dear, dear friends, has been a longtime attorney here in Charlotte, but has the unique experience of being both a prosecutor for many, many years, including being a homicide prosecutor, as well as being a defense attorney, and handling all types of cases, and in particular serious felonies, as I do as well. So my guest, you know him all too well. So welcome to the show, none other than attorney Rob Corbett. How are you tonight, dear? How are you doing?
I'm doing fine, ma'am. Thank you. Thank you.
Well, thank you so much for joining us again tonight. For those of you tuning in, or if you're catching the replay, make sure you drop your comments, drop your questions. If you're tuning in at the watch party, drop a wave so that we see you. You can also drop your questions in the watch party because I can see those there as well. So let's start with the big issue. And this is really a question for everyone. But Rob, I'll start with probably the most important question in terms of, we'll start with Breonna Taylor first specifically. What was your reaction? What was your reaction to the indictments when you first heard about it? What was your initial reaction?
My initial reaction was, I thought in terms of how this was tragic and unfortunate how it was coming down. And then I sort of changed a little bit, because I thought by describing it as being tragic or unfortunate, that somehow made it sound as if this was unavoidable, and it wasn't. When we first talked about this, I think we may have said I may have said that based on the delay in the investigation, that I wouldn't be surprised if no indictments or no charges were sought. And when that came out yesterday, in terms of, especially after the settlement was already announced, of where, and even though I don't necessarily participate or do those kind of cases, I think it is rare that the settlement is made prior to any criminal charges, and that the settlement is made public, of where that you don't have a clause of where you say, look, we're going to like settle this, we're going to agree on a specific sum, but you can't go out and talk about what that sum was. And they
Right.
did all of that ahead of time, which just sort of solidified for me that I thought, use shenanigans or say okey doke. I thought that's what was coming down.
Mm-hmm. And so the settlement itself was significant, I suppose. I mean, I guess that's relatively speaking. We're talking
Right.
$12 million. And I think the reaction from a lot of people was probably the same. Like, why would they settle so quickly and be so open? Because usually there's a confidentiality clause or a non-disclosure agreement that those things can't be discussed. So when you saw that and your inclination was, they're probably not going to pursue charges, why do you think, as a former prosecutor, well, let me say it differently, as a former prosecutor, particularly in homicide cases, what in the facts did you think that may have been problematic? Let's take the politics out of it, because we're going to get into that in a second. But
Right.
what do you think some of the issues that, if you were looking at this with the lens, without a political lens, that may have
Right.
been problematic?
Yeah, so without like political lens, my issue with these types of cases, or when it involves a shooting by police, is to how there's always this care, or we have to make sure that we have to have the investigation is so drawn out, where if it is one of our clients, we know that if there's an allegation, they're arrested, and then police will continue to interview people and find evidence after the fact. But here you want to make sure that you have everything. So when you have 6 months from, time that it occurred to now and nothing, then that's why I was sort of thinking that, hey, okay, they're not going to charge. But the things that, if I'm looking at it from, you said, non-political lens, is that you have two things sort of competing, in that you have castle doctrine and you have self-defense. Castle doctrine, you have the right to defend yourself in your home. That's, if you think about it, there's one place we should be safe, that's going to be in our own home. So that's why her boyfriend, Mr. Walker, when he was originally charged with attempted murder, they dropped that because he had the right to defend himself, defend her. And then you have self-defense competing with that, in that the officers had authorization, a search warrant signed by a judge to go into the home. And that's problematic in terms of why they felt the need to go there that time of night, what they were looking for, knowing that already had information she was not the main target, but they had authorization to go into the home. So when Mr. Walker fired, the law allows them to act in self-defense and return fire. And when you have those two things competing, prosecutor is looking at what is the likelihood of success at trial. Not that I want to 100% get a guilty verdict, but what is the likelihood that I can get this past reasonable doubt? I have to have some chance to do that. And if you don't think you can do that, then charges shouldn't be pursued.
And so now, given the fact that those two doctrines are in competition, castle doctrine and self-defense, a lot of people ask the question, and I thought this was interesting last night as I was watching an interview of Mr. Walker's attorney. And Mr. Walker, if you don't know, was the alleged boyfriend of Breonna. And he was going ham on Anderson Cooper when he was talking about how much information that he obviously has seen that the public is not aware of, and so much that was inconclusive as far as the ballistics. And the problem is that we as the public, we can't weigh any of that. And that's important when we're thinking about this in terms of the grand jury. So for people who may not know, Rob, so, obviously, well, it may not be obvious, but grand jury proceedings are secret. Why is that? And why is it that we don't have an opportunity to know what was actually presented to the grand jury?
Yeah, so grand jury proceedings are secret. Grand jury members are people that are selected from the community, and they typically would serve a term 6 or 12 months. And you have that secrecy, that anonymity, so that charges can be presented. People don't have to worry about any reprisal or people coming after them. But it's one-sided usually, in that the defense doesn't have the opportunity necessarily to come in and say anything. And the reason why that's important is that the saying that people say all the time, if a prosecutor wants to indict a ham sandwich, then they can. Meaning that if a prosecutor wants someone indicted, they get indicted. And even in my experience when I was a prosecutor, the rare times of where if the grand jury did not return an indictment, we have two grand juries in Mecklenburg County and they alternate weeks. If the first week that grand jury didn't return an indictment, we just send it to the grand jury the next week and just have, if we had the wrong officer or somebody didn't testify to something, we just send it and you get the indictment. So if you want it, you get it. So what I don't like is if a prosecutor punts to say that, hey, I don't know what we want to do, so we'll send to the grand jury and let them make the decision. Prosecutor's office needs to be able to say or come out that yes, we have evidence, or no, we don't.
Mm-hmm. And so, do you think it's possible, because I think this is one of the questions that was raised, that they could resubmit charges, resubmit it to a grand jury for the two officers that were not charged who actually shot her?
Well, it's possible, but I don't think it's likely in light of comments made by Attorney General Cameron, in that I think he said for their local lab, the local lab was not able to determine of the shots fired, which officer fired the fatal shot. The FBI was able to determine that the fatal shot was fired by the names are Cosgroves, Mattingly, Cosgrove, and Haskins. The fatal shot was fired by Cosgrove. And then the AG, Cameron, stated that because of those conflicting reports, that's built in reasonable doubt, and that they wouldn't be able to get beyond that. But nonetheless, they had already concluded that the shooting was justified. So because of those statements, I don't see them resubmitting if they were able to get additional reports.
Okay. And so for those of you tuning in, if you have questions, especially if you have comments, because the question that you see on the screen is where I really want to hear from you guys in terms of what was your reaction to the indictments in the indictments that were actually returned in the case. And more specifically, if you had an opportunity to hear what Attorney General Daniel Cameron said in his justification for not proceeding with the other two officers and discussing the case in his press conference, then drop your comments, because we want to talk about that too as well. So, okay. So then the other issue then becomes, okay, so the actual indicted charges, for people who may not know, were what?
Of the three officers, Mattingly, Cosgrove, and Haskins, only Haskins was indicted. Haskins was the officer who was fired. The other two officers, I think, were reassigned to administrative duties pending investigation, but Haskins was fired. Haskins was charged with wanton endangerment. And under Kentucky law, because we don't have that in North Carolina, but under Kentucky law, that is a felony. It's a Class D felony, and it's punishable by 1 to 5 years and a fine. And wanton endangerment is a disregard for human life. So with the allegation against Haskins is that Mattingly, when he went through the door, that's when Mr. Walker fired, and Mattingly was hit in the leg and then returned fire. Haskins, I think, is out. Well, the other two are outside, and Haskins fires through a sliding glass door as well as a window, both which had the blinds or the shades down. So the police were saying Haskins did not even have, Haskins did not even have a line of sight, couldn't even tell who he was shooting at or who was inside. And that's why part of the reason why they fired him and why they only indicted him for that charge.
And isn't the problem, though, because I mean, this happens in jurisdictions all the time. Like, Haskinson's fired, but he was a detective. He didn't lose anything. I mean, in theory, he could just go to another jurisdiction and start over, or continue his career in law enforcement other than the fact that he was fired. I mean, he's not radioactive. I mean, he could get a job somewhere else. But here's the thing, though. Isn't it possible? And I think this is probably what a lot of people have issues with. Okay, so we know that local lab says inconclusive, right? FBI says it's Cosgrove's gun that fires the fatal shot. While there is inconsistency there, why would you still not proceed? And that's a battle of the experts. The jury can decide which expert or whatever they are. If there's an independent expert, that they can make that decision. I think a lot of the uproar is, and Eric, I hear you, that people find that that is disrespectful, frankly, as a treatment of women in general, especially given the level of attention this has. But why not submit it anyway? I mean, if we know that they can indict, why not submit it anyway and let that be a question for the jury? Who's Daniel Cameron's position to say, yeah, but that's a problem with the case? No case is perfect. There's problems with cases all the time. That's the whole point of having the jurors being the finders of fact, not an individual prosecutor or an attorney general.
No, I think that's a good point in terms of, and I don't think that's unusual. That, because I can even think of in terms of where we may have had that occur locally, of where we have Charlotte Mecklenburg Police Department has its own crime lab, and I'm sure there are cases of where a lab was, we have a DNA report from the crime lab here, and because of, and I'm not the DNA expert, but they'll send it to an outside lab because they can do more fine tune the test. And then that lab will get the report, and that lab will have additional information. And then that's why the prosecutor can say, okay, we're able to link it to this suspect because our lab couldn't find out something, but we sent it somewhere else. So that would be just by itself, that I can see that as a scenario that would be enough for them to charge. But why, if I'm still looking in terms of prosecutor hat on, they had already concluded that the shooting was justified. And that the FBI said, Cosgrove, you fired the fatal shot, and AG Cameron and whoever is working on the case with him, assuming he had other people working on the case with him, are already saying, know that. Yeah. Well, besides like Mitch, right, are already saying that the shooting was justified. So I think that negates it on their part. But there's so much that we don't know about the case, what evidence was presented. And that's where where transparency, especially in a case like this, would be helpful. And I think the mayor or governor has asked for that.
And why do you think it's such a problem that they've not even responded to that? And you're absolutely correct that the mayor and the governors asked for this information to be released and no response.
Yeah, and that's a disregard, I guess, for your constituency and not caring what the people or the community that is most affected, how they feel about this. Because there's no law that states that they have to, but in order to maintain public trust, you would think, hey, I would want to do this. I would want to get ahead and tell you all this is the decision that we made. But he hasn't done that. Let's just say he punted by saying, it was a grand jury, they did this, where it was the AG's office that made the decision.
Right.
But you may have that in terms of when we talk about how it's important to vet people. I don't think he's tried a case or tried this kind of case. He went from being a clerk to working for Mitch, then working at a civil law firm in Kentucky for a year, and then ran for office.
And it helps, who he's married to, but yeah. All right. So, okay. For those of you just tuning in or just chiming in, make sure you drop your questions in the comments so that we can answer your questions, because we're covering the Breonna Taylor case, and we're also going to talk about the open seat in the Supreme Court and what that may mean in a larger scale. So do you think, as a former prosecutor, because we're going to also talk about this from a defense standpoint, do you think that the prosecutorial system needs to have some sort of reform? Because prosecutorial discretion there's no limit to it in some ways. Is that a system that needs to be reformed? And let's say hypothetically the answer is yes. Like, how do we do that? Is there something that we can do individually as citizens to be able to push for that, other than making the decision who the prosecutor is through the power of your vote?
Yeah, I can't think of a way, at least like at this point, of where we can do in terms of how do you affect prosecutorial discretion outside of voting for in terms of who you have as your prosecutor, or in this case, who you have as your AG. Because I was talking to someone, the local DA farmed this out, sent it to the AG's office, which generally I think that's a good thing. I think these cases should go to the attorney general, and therefore you don't have to worry about if a DA's office is too cozy with their local police department because they work hand in hand on cases. You get you a third party to come in. But here they got the third party to come in, but this is what you get. You get somebody who is not familiar probably with criminal law, who does not try cases, and whose office is not being transparent and showing the public in terms of how this decision was made. And what recourse do you have outside of next election? He gets out. But there's so many, but there are problems before you even get to the prosecutor's office in terms of how this whole case developed.
Talk about it.
Well, in terms of you have Miss Taylor's ex-boyfriend, Mr. Glover, I think, who had already, at least someone had already been arrested prior to them going to Miss Taylor's home. They, they applied and got a no-knock warrant, which states that you don't have to announce who you are before you go inside someone's house and search them. The judge approved that. Prior to them getting there, though, they were told to disregard the no-knock part because Miss Taylor was not the main target. They characterized her as a soft target. So knowing that she's the soft target, knowing she's not the main person that you're looking for, then why still proceed with doing this, entering the house after midnight? You are creating a dangerous situation. You're putting people, communities in danger of where, and we all talk about in terms of what we know intrinsically. If you had switched this, it'd be probably a different outcome. There's a different outrage, meaning if you put black officer breaking into white couple's home and white guy is shooting to defend he and his girlfriend, an innocent white woman is killed, that's an outcry. And people are saying, hey, we got to change how we're doing things. And even if you still come out the same way, but people are still looking at that. So where the problems with they change, you don't need no-knock warrants. Go for what they create. They shouldn't have gone there, like say at the middle of the night. They could have waited early morning hours or just got on the bullhorn and just say, hey, we're here. We need you to come outside. If you're worried about her, if you think something is there and you're worried about her destroying or trying to get rid of that evidence.
And so let's talk about the search warrant real quick. But I've got a couple questions, and Benita, I'm not sure I understand your question. If you can drop it in the comment again. But Robert Fasik asked, are there not considerations in grand jury deliberations or prosecutor discretion of what alternatives were or might have been available rather than the use of lethal force? Especially given the fact there's no body cams, we don't know what really happened other than what they said happened and what they put in their report, which is self-serving.
And sorry, say that part in terms of, is there, I missed the grand jury part.
He said, are there not considerations in grand jury deliberations or prosecutorial discretion of what alternatives were or might have been available rather than the use of lethal force?
Oh, yeah. And I would say probably not, in that when a case is presented to the grand jury, it's not necessarily showing in terms of, hey, this is all the good and the bad of the case. It's does it meet that low threshold? We say like probable cause, which is a low threshold. Is there some evidence to charge? And that's why we say if they want you indicted, you get indicted. You can't stop that normally. So we don't know what was presented to the grand jury, and it's presented in such a way probably that they don't want the grand jury to return indictments. And I'm not even clear if it was presented on all three, if they went to the grand jury on all three officers and the grand jury returned no true bill or didn't indict on two and they just indicted on one. So that comes back to that transparency. We don't know what they did.
That's incredibly important for people who are watching, especially if you're catching the replay, because the fact that these proceedings are secret, we don't know if they even presented any evidence on the other two officers who were actually responsible for the bullets that ended Breonna Taylor's life. And so, for all we know, they could have just presented just enough evidence to get the indictment on the wanton endangerment, and then didn't present anything else, and then say, "Oh, well, they didn't indict." But we don't know what they presented. So, Robert, that was a great question. I want to pivot real quick to the actual search warrant, because one of the big things that I think is that legal heads and people who are looking at it from that perspective, but may not be something that's really discussed on a lot of the news outlets, is the warrant itself and the issues with that. And so, the warrant itself, like you said earlier, was a no-knock warrant, but what they used to gather information to even justify it was so stale, because they referenced an incident about a guy coming to the house and picking up a package back in January. And that was the crux of the information that was, I believe, was in January the 16th, if I remember. But the shooting, of course, happened. The murder, of course, happened in March. And that was it. I mean, that was the extent. There was nothing recent, no recent information about her, any movements by her, anything like that would have justified. And like you also said, and somebody else comment, is the issue that the person that they were interested in was already in custody. So what say you, having, I know, presented and having not presented, but having to deal with search warrants countless times as a former prosecutor, what say you to that as far as the strength of the warrant itself?
Yeah, I think the warrants need to have some specificity in that they need to say, in terms of, this is why, based on our training and experience, this is why we believe what we're looking for is going to be in that home. And even if, and there was some issue with the judge who granted the warrant, and people were saying, well, she just rubber stamped it. And, I think she pushed back, or some of her colleagues pushed back and said that no, in terms of, she didn't read it, it had plenty of detail. But if the information is that someone did this in January, even if you grant that warrant, this isn't there's no immediacy for you to act on at this particular time of night on March 13th. I mean, so even if you get the warrant, it goes back in terms of, you can wait. The issue of that Glover, the ex-boyfriend, wasn't living there, I don't have so much as a problem with that, in that, I know, because when it first came out, I think the story was, hey, they went to the wrong house or what have you. And the information we have is that no, they didn't go to the wrong house. They went to her house with the belief, though, that something was there, which just ties into the fact of, she's not involved. She's not the queen pin. They know this. So there's no need for you to have acted at this particular time of night and breached the house, which is, like I said, creates a dangerous situation.
So another question, going back to Benita's question, and SIL, I'm not sure if I'm understanding your question. If you can rephrase it, perhaps, so that we can answer it. But Benita is asking, how often is evidence conclusive from a local perspective? When we were talking about the difference between what the local lab and what the feds found, and we can't say how often, because every case is different, but in general, as far as evidence from a local perspective, if a county is even lucky enough to even have a local lab and not have to rely on a state lab. That's a good question.
For Charlotte has its own lab, and vast majority of cases I have worked on, in terms of from both sides, we relied on the local lab. Other counties that don't have it, then their materials are usually sent to SBI lab in Raleigh. So that is the only example that I could think of, was where, in terms of a case involving DNA and local lab couldn't quite determine something for a particular reason. And then it was sent out to a lab, like in another state. But the majority of the time, you have your own lab, then that's you go with that. And then but by saying that, then the question is, does that play a part in their decision? Meaning they said, look, we have a lab. This is the lab we use for our cases. This is a lab that our community uses as we enforce or prosecute cases. Our lab said it's inconclusive. And so we're going to go with that. But that doesn't prohibit them. They can still go with the FBI lab. Nothing says that they can't use that one.
And so another good question from Robert Facey. He says that the governor is stating that he thinks there is no reason to keep a large part of the proceedings secret. What are the pros and cons of releasing transcripts of grand jury proceedings? And even if it's not releasing the grand jury proceeding transcript, but just releasing the information that was actually presented, even if it's not in a transcript form. That's a really good question.
Yeah, I see no cons unless someone is worried that this sets a precedent, that by doing this, now we're going to have to do this in every case. And this is a unique case. This is a case that has captured the world's conscience. So everyone is familiar with it. So there's no cons. The pro is it's not going to assuage concerns. There's still going to be people who aren't going to like the decision, but as the government official, I think you have to do something. You have to take that step to allow people to know that, look, you may not agree with what we did or how we reached this conclusion, but this is what based on our analysis, this is what we thought we could prove. And it's why we are not proceeding with charges in this case. And like I say, you're not going to make everybody happy, but yeah, as a prosecutor, I think you at least need to do that.
And so one of the things that I found interesting, and I don't know if the viewers found this interesting as well, but they were justifying the no knock part of it, saying, well, it was a no knock warrant, but we announced that we were the police before we entered, and none of the witnesses initially could corroborate that. They all said no one heard them yell police or say police or any of that. But then there was one witness. And what we do understand, or at least what's been reported in the news outlets, is that one witness said at least 2 times he was interviewed, no, I didn't hear them say anything about police. And then the 3rd time he said, yeah, I heard them say the police. And what it looks like is that they were relying on that, at least in the grand jury proceeding, to indicate that they did announce who they were, and in part, perhaps, to justify their actions, making the assumption that Mr. Walker heard that and still shot out anyway. Right. So having interviewed witnesses, and you and I both know, particularly as defense attorneys, interviewing witnesses and what they say initially is almost always paramount, because memories fade over time, things change. What do you think? And of course, we're both speculating, but the fact that everybody said, nobody said police, nobody said police, nobody said police. And then eventually he says, yeah, I heard him say police. If they use that information in the grand jury, do you think that would have been intentional to sway them in terms of returning or indicting simply on the reckless versus pursuing a manslaughter or murder, which we'll get to in just a second?
Yeah, I think absolutely. And it's what I tell clients of where if we do a bond hearing right after or soon after they've been arrested, and I tell them that what you see in the arrest affidavit, which is what the officer detective uses to talk to the magistrate as to why charges should be issued, is always going to be a little different. And it's usually is going to be swayed to the officer's viewpoint, and that the arrest affidavit will say witnesses saw John Doe running down the street. And then once you actually get the evidence, they don't say John Doe running down the street. They say, I saw a man wearing a white shirt and jeans, and I thought that may look like John Doe, but I wasn't sure because it was too dark. So when they go to the grand jury, it's the same thing. They don't even have to say that, but they go to the grand jury, and what's presented, if it's a county, if it's a state of where people testify, like you might do in federal court, or it's just the officer testifies, they would have said, we knocked on the door and we announced ourselves as police officers, and there are witnesses who have given statements. They said they heard us say that. They don't have to introduce anything else to contradict that during the grand jury proceeding.
And I'm gonna come back to that in just a second. Vicky, no, I can't see your question from that watch party. Just drop it in the comments because I can't see it here. One other question before I move on to one other topic real quick, but Benita asked, did qualified immunity play a part in the minimum indictments at all?
Yeah, I had Someone, well, my fraternity brother, so that's Kappa Alpha Psi Fraternity Incorporated.
Way to
He,
put in the shout out.
he practices out east. But we were talking about that. He had mentioned that, and that applies for civil cases if you were suing the police officers. So it wouldn't go necessarily in here, but maybe the same fault in that a deference is giving to police officers who, especially like there are no body cameras, there's no evidence really or witnesses to contradict what's happening in those close quarters. And the officer said, this is what happened. This is what I felt. We felt our lives were in danger. We returned fire. So the analysis is they were justified in that moment to use deadly force, at least Cosgrove and Mattingly. And then for Haskins, they're saying that for you outside, not even having a proper line of sight, can't even see where you're shooting, that was too far afield. And that's why he got indicted.
And so what I thought was really interesting when we were talking about this no-knock warrant issue, and there's legislation, for those of you who don't know, that the House has already passed in wake of George Floyd's murder that is still sitting on Mitch McConnell's desk, won't even bring it to the floor, that will deal with the issue of chokeholds and no-knock warrants. Some of the research that I did the other day, and I actually heard, I can't remember, the representative said that between 2010 and 2016, specifically as it relates to no-knock warrants, at least 96 civilians have been killed and 13 officers have been killed in wake of using no-knock warrants. Now, some people are getting away from them in jurisdictions where they're still there. But the issue is that, and it's like you said at the beginning of the show, especially if you've come in a little bit later in the show, Rob was talking about how this whole case is this collision, if you will, between the Castle Doctrine and self-defense. And the issue is that no-knock warrants obviously allow to enter without knocking or announcing yourself. But then you also have the issue of being able to defend yourself in your own home. What say you? And I'm really curious as the women that are watching, how you feel about this, because a lot of issues that women are feeling are specifically, and I've seen it in some men's social media as well, but women are feeling, Black women specifically are feeling like, oh, we're sick of this. We're sick of being, disrespected. We're sick of feeling like our lives don't matter. We're sick of feeling like, had this been a white woman, this would have been a completely different scenario. The outrage would have been different. The defense that would have been coming from the NRA to, back up Mr. Walker for shooting in the first place, or all of those things would have been very different. But I also saw something that was really interesting in a couple of posts from Black men. Didn't respond. But the gist of what they were saying was that she could have made victimizing the victim, basically.
Right.
She could have made other choices. She didn't have to be with this guy. They were already looking at her. She's not an innocent victim. And it was so disheartening to see this from other Black men. You expect that from someone who is white and racist and doesn't get like why we are so upset as people of color, Black, white, or whatever, like why this case is so upsetting, why this case brings up so much emotion, especially the fact that it's gotten so much attention. But specifically from women, I think the thing that, like I said, I find so disturbing is that Black men are still not coming to our defense and our protection. It's, oh, she could have made other decisions. She was asleep in the bed. There was no drugs found in the house. There were no large amounts of money found in the house. Nothing that suggested that she was a drug dealer or any of that. And yet, and still, people will still blame, or still trying to create the narrative that she should have made different decisions and she'd still be alive. What do you say to that? What would you say to another Black man who is making comments and statements like that?
Yeah, I saw one of those posts earlier today, and if I'm pronouncing the word correctly, but misogynoir is a real concept and it affects too many people's mindset. That is absolutely 100% the wrong take. There is nothing she did that warranted that outcome. There's nothing that she did that brought this upon herself. this narrative is too often in these types of cases of where we have to be 100% perfect, walk this straight line. And even when those cases where you do, tragedy like this can still come upon you. But specifically, though, to Black women, in terms of, to use part of Malcolm X quote, the most disrespected person is the Black woman. If this had been different, if this had been, you change it to white woman who's killed, innocent white woman killed in her home, there is that outrage. There is gun rights advocates coming forward and saying that this is exactly why we have the Second Amendment, to protect us from things like this. And even if it's the same outcome, or if it wasn't in terms of for charges, I may still be arguing the same way in terms of the analysis. But I think it is viewed, this case is viewed differently because of who the victim was.
Mm. And so let's say hypothetically where the grand jury has the option of murder and manslaughter. We don't know if they will even present evidence for that, but let's say that they were. As a prosecutor, and then we're going to put on our defense attorney hat for a second, but if those two things were presented, murder or manslaughter, what do you think would have been a charge based on what we know of the facts that a jury could have returned with if that evidence was presented?
Yeah, I think murder, as prosecutor, I would still think murder is too high. Kentucky's homicide charges are broken down into murder, first degree manslaughter, second degree manslaughter, and reckless homicide. Murder is too high, I think, as a prosecutor, because that involves the intentional killing with malice. First degree manslaughter is the intent to do physical harm. Second degree manslaughter is reserved primarily for vehicular homicide cases. So, you take that out. But I can see in terms of reckless homicide, in that you are acting in a reckless, careless way and you cause the death of another, especially as it relates to Haskins. If ballistics had shown that the fatal shot was fired by Haskins, then as a prosecutor, because like I said, you're not thinking that I have to 100% get a guilty verdict, but you need to be thinking that my evidence justifies that charge, and it justifies me going in that courtroom. If the jury comes back and says no, so be it. But I have evidence, and I can argue it with a straight face. So if further ballistics show that Haskins fired the fatal shot, and we already know that Haskins is firing all willy-nilly through closed windows, then I think there's an argument that he can be charged with that. Or if not reckless homicide, then they also have aggravated assault.
And so before we move on to the Supreme Court issue, we got to we got to talk about the political hat for a second. And Vicky, I still can't see the question, so just drop it in the comments from where you can see it. So, Mr. Cameron, if you are joining us a little bit later, we had talked about him earlier. And it was interesting when he became AG in legal circles. We were like, okay, this is interesting. He's Republican, but we don't know. But a lot of us, well, not a lot of us, most of us found out that, what his political ties were as far as his relationship, having worked for Mitch McConnell, being married to his niece, all of that. So let's put on a political hat for a second. How much of this, and I'll pose this to the audience as well, how much of this do you think is potentially just a cover-up?
I hadn't thought of it in terms of cover-up, in terms of that they have evidence that conclusively shows that would point to some other charge, a higher charge. So I don't think, and and when I say that I don't think of it, I have no reason to say that it's not. So it's like I can't say that it is. But maybe my inclination is I give people too much benefit of the doubt and think there's some honor and integrity, but that they looked at it, and not having experience of working on these cases. And maybe you get like pressure in terms of, we are, as a platform, we are pro law enforcement, especially in these types of cases, and that we have been endorsed by all of the or majority of the police unions, and that you take a good look at this, and then we know you're going to do the right thing. So it's all in terms of how you view it. If you view this coming in with the lens of they're absolutely right, then you're looking for evidence to support that.
Mm-hmm. And so the last thing before, I move on, and Vicky asked, did they ever conclude the fatal shot didn't come from him? Now, Vicky, not sure if you were talking about Haskins, but the fatal shot came from Cosgrove, not from him. So, but obviously he wasn't charged. The two people who fired shots that actually killed her, neither one of them were actually indicted for anything. And Hackerson was only indicted based on the shots that could have actually harmed other people that didn't actually harm Breonna Taylor. So that's the tragedy in all of this. And so, for those of you joining us, if you still have questions on this, we can come back to this as far as Breonna Taylor. But with the time that we have left, I do want to pivot just for a second to kind of talk about what we need to do now in wake of what is going to, or what we're looking at and what's at stake as far as the Supreme Court is concerned. So, as you all know, Chief Justice Ruth Bader Ginsburg died from complications of pancreatic cancer on Friday. And I posted briefly just because it just was a lot. I think a lot for a lot of people, whether, you follow her legal opinions or whatever, because, let's face it, at the end of the day, she had been dealing with health challenges, but she has beat cancer, 3 times, maybe 4. And, her passing was it was so unexpected. From a personal note, I ended up going to DC on Sunday. I just woke up with it on my spirit to go and lay flowers at the Supreme Court. And every time I've been to DC, I don't know, maybe 20 times, never been to the Supreme Court, although I always said I was going to go. And so when I went, it was really emotional because the first thing that I remember seeing was this flag that was waving where, these 2 women were directly in front of the Supreme Court, and they were waving this huge flag that had Justice Ginsburg's likeness on it. It had Notorious RBG, and they were just waving it. And they couldn't leave it there because every time they stopped waving it, somebody from security would come over and tell them, hey, you can't post it up here. But there was press everywhere. Apparently the night before, I didn't make it to the vigil, but apparently the whole plaza area had been full the night before with flowers. Found a place to lay flowers, talked to a couple reporters, and there was CTV out of Canada and then a local station in Baltimore, and they asked about, what does this mean? And so I just kind of talked about it from a basic standpoint. But there's 2 things that I'm curious about. One, what was your reaction when you all found out she passed? Drop it in the comments. But 2, what is your perception of what do you think this means for what's going forward, assuming that this seat is going to be filled? Because the second part of this discussion, why I call it justice denied, is because Justice Ginsburg's final wish was that her seat would be filled by the next president. And of course, the hypocrisy, the sheer unadulterated hypocrisy is that we all know that when Justice Scalia passed away and Merrick Garland was President Obama's pick back in February, Mitch McConnell, see where I'm going with here, Mitch McConnell and Senate Republicans refused to even bring his nomination to the floor, citing the fact that, we're in a presidential year and it's the people that should make the decision in terms of who fills that seat. Fast forward in November. Yeah. And so, of course, we know the elections have consequences. Okay, so fast forward all of that. And so here we are now where the man in the White House is looking at a woman to replace Justice Ginsburg. The reality is, people, like I said, elections have consequences. We would have to count on 4 senators having enough gumption to actually listen to the will of the people versus not making a decision based on politics to keep that from happening. we all know that this Senate refuses to do anything on COVID relief, refuses to do anything to help the American people in any real substantive way, or funding, reasonable research to give us a vaccine that's not going to kill us all and have horns coming out of our heads or whatever. But we can push. They made it very clear they want to push through this nominee. So what does that mean? On a basic level, what that means is that if it comes to the Senate floor, Senator Feinstein has already said, I mean, there's not a whole lot we can do. We can't stop that train. Now, whether or not it gets through a nomination process and a vote, that's where the rub is. We're 40 days out. Now, whether or not, even if he announces on Saturday, do they have enough time to be able to get it through committee, get her to the floor and get a vote before November? I just don't think that's possible. I'll just put it out there. Now, the question becomes, and interesting politically, is let's go ahead and hold up. I don't know if I said if. Claim this, y'all. When the circus peanut is out of the White House, then the question becomes: will potentially a lame duck Senate, if the Senate is flipped, and would a lame duck president still push it, and would he still have the votes to be able to get this person in? So, I see a couple questions. I'm gonna get to you guys in just a second. The person who is now emerged as the front runner is Amy Coney Barrett, and she is out of the Seventh Circuit. She has practiced very little law. She was a professor for just over a decade, and she was Justice Scalia's clerk before she went to practice law for a shorter period of time, and then became a professor, then went to the Seventh Circuit. That in and of itself is, I think, problematic, but whatever. I mean, it's just something to have justices or even judges that have never practiced law before. It's an issue, just like it's an issue in Kentucky with an attorney general who is not really practiced law other than doing some civil stuff, probably barely stepped foot in the courtroom, but I digress. What does this mean, guys? Well, one, it means the Affordable Care Act is going to be up for debate the week after the election again. And if the seat is filled, I doubt the seat could possibly be filled by that time. But let's say for, the purposes of complete horror that it gets filled, she has made it very clear that she is anti-abortion. She's made it very clear that she's against the Affordable Care Act. In fact, had a lot to say about Justice Roberts' opinion in that. And she's only been a federal judge for 3 years. That's it. She's the front runner, y'all. Now, there was some talk that there was Judge Lagoa, she's Cuban American, that out of Florida, that she may be in the front running, but they don't have time to vet her. And Barrett is probably an easier pick because she was vetted, but Kavanaugh got picked over her during that time. So, Rob, I'll ask you, and I'll ask the audience. And Erica, that's a great comment. I'll get to that in a second. But we should all be very, very, very concerned about what this means as this pendulum swings. But as students of history, it swung from the Burger Court and all these other things. I don't want to get into a rant, guys. But the issue is that we should be concerned because let's say the Affordable Care Act is struck down. Trump, oh my God, I can't believe I said his name. but there's no plan. There's been a promise of a plan for a year and a half. There is no plan to replace it. And there's little inclination that even if the House passes something, that the Senate would take that up. So I'll ask you this, Rob, and I'll ask everyone else. When you found out that she passed away, one, what was your reaction? And two, what do you think that means from a defense attorney's perspective and what we may see change as far as the protection of rights and civil liberties under the Constitution?
Yeah, when I first heard of the passing of Justice Ginsburg, my first reaction was how valiantly she had fought, because I believe that was obviously her intent to stay on the court until after the election. And then what this possibly means is that there is currently a split in the court, and with Roberts coming in and being the tiebreaker. And you're going to potentially have a 6-3 leaning conservative court. And it's, the judicial is just like one, it's just one of three branches that we have of government. There's supposed to be these checks and balances, but by having that shift, that's going to affect us for generations. It'll be like grandkids will be considering or looking at who's going to be replaced on the court based on, like, the age that we have. Those certain liberties that we currently enjoy is potentially in jeopardy. Abortion rights are potentially in jeopardy. 45 has made comments about how he refuses to say there will be a peaceful transition of power. And this is something that has to go to the Supreme Court, like it did with Gore v. Bush. Is that something that has to be taken into consideration? And does that factor into the rush to get someone nominated and approved before the election? The Supreme Court or overturning Roe v. Wade, that is a tenet of the Republican Party in terms of that's what they have wanted. Now, when I think about in terms of what can be done, you have precedent in terms of what happened with Obama. He tried to nominate or make the nomination 9 months before the end of his term. They're not following that. Doing mental gymnastics to show why this is different. Constitution empowers the president to make a nomination, and Democrats should do in terms of what they can to try to stop, derail, or make it known that, and I've involved on this, that if it goes through, then you have that possibility of adding more jurists, adding more justices to the Supreme Court bench. Because all it is it's a rule change. I mean, because I said earlier, the number 9, that wasn't given to us by Moses. That's just been the number, though, since 1869. But that can be changed.
That's right. And, there were calls for that immediately, probably not directly from House members, but certainly from the public, as far as increasing that number to 11 and more leveling the playing field. Erica Ellis Stewart asked that whether or not we could talk about the hundreds, and she's not lying, y'all, the hundreds of federal judicial appointments that have quietly gone in under the radar, and what are the implications of those appointments? That's a great question. You want to take that first?
Yeah, in terms of that's the legacy, in terms of stacking the course, in terms of what they say, what in addition to what 45 has done, is going to be that a problem like 200 federal judges and 2, maybe 3 Supreme Court justices. So you think about that in terms of how cases go through the system, or how Fourth Amendment rights can be eroded based on these decisions. That's going to have a significant impact for years to come.
And especially in the circuits where there were circuits that were, I don't say better or worse. I mean, we're in the 9th. Yeah, it's, for certain things that come up on appeal, it's hard just because of the precedent that's there versus the DC circuit, which is a little different. And I think that's important. And Vicky chimed in, it's 198. I didn't even realize it was that many that have been pushed through. And those are lifetime appointments. And the issue is that we have to be aware, and especially for us as attorneys and doing defense work, what's legal with a traffic stop, or how far a search can go, or, what's the definition of consent to search. All of those things become important. Is it still okay for an officer to say, hey, I smell weed and now I can search your car for whatever it is that they may be looking for? Is it possible that Miranda rights could be eroded? I mean, there's any number of things that we have to be very mindful of. And unfortunately, we can't go back in a time machine and change it. We do know that elections have consequences. So if nothing else, I hope this ignites all of you that are watching or catching the replay or on social media to make sure people who might not be as excited as you are to vote, that we are underscoring the importance of voting, especially. I mean, our democracy is at stake, frankly. Our republic is at stake. Our health, our other Americans are at stake. I mean, we crossed 200,000, 202,000 people who have died of COVID-19 at this point, and we still don't have a plan at all. But to your point, Erica, the issue as far as those appointments, it addresses everything from election interference with PACs and all of that came from Citizens United. And I think the fact, and Rob, you make an excellent point that, you have a president who we don't even know if he that still refuses to say there's going to be a peaceful transition of power when he loses, and still trying to stoke fear as far as that's concerned. So now Curtis made a comment, and I think this is probably part and parcel with how a lot of people feel about Justice Ginsburg, is how powerfully she really spoke to protect people and to speak for people, to speak for women specifically. If you haven't seen the CNN special, that one is phenomenal. You got to see that. And then there's 2 other movies that are out and one that's coming, so that you can see, part of what, the impact that she's had. So, okay, Rob, so let's say Coney Barrett gets it. Well, let's say it differently. Let's say they can't push her through before November 3rd. November 3rd comes, and hallelujah, we take the House and the Senate, and the circus peanut's on his way out the door. What's the likelihood that this Senate would still push to allow her pick to go through, even though that he's on his way out the door?
I think they would, and I'm basing that on the importance that has been placed on getting a conservative on the Supreme Court. So especially if the House ends up flipping and some key senators lose their seats, and that they are still, McConnell can recall them back to session. They can say, look, we're done with 45. We don't have to worry about that. But we have significantly impacted the judiciary, as you stated, the 198 federal judges. And here is our opportunity to get someone, a conservative, on the Supreme Court, because that Biden isn't going to pick her. Biden will pick someone else. And Biden has committed to picking a Black woman for the Supreme Court. So I see it as very likely that either scenario, I think McConnell can see that we don't get it done now, or at least definitely wait it for the lame duck session, regardless of what happens. And then if you wait for the lame duck session, it doesn't have to become as much of a political football by people having to answer questions of why did you do this? And they can fall back and say, we haven't done anything. We're all waiting, and just do it after November 3rd.
And one thing I do, before we wrap up, the one thing I did want to focus on, because one of the things that pops up in the media a lot is the potential of Roe v. Wade being overturned. And what I think, not saying this from a legal analyst perspective or anything, but I think what would ultimately happen is that the right would still be there. But I think it would make it easier for states to make it harder for women to be able to obtain an abortion, regardless of the circumstances, whether it's, rape or incest, or if it's medical or whatever the case may be. And that's the horror. We as women, regardless of how you feel about abortion, that's the horror of it, because that's what takes us back to the 50s and 60s, where people had to cross state lines because the state laws were different. That's the thing that we should be concerned about, because it would still allow it to happen. I mean, my goodness, you can't completely outlaw it, but some states can make it more difficult than others to be able to allow women to make that choice. We should all be very much concerned about the Affordable Care Act, because there's, if they overturn it, then obviously the result is that the Senate has to do something, the House and the Congress has to do something in order to replace it. What is that going to be? If there's no individual mandate, does that mean pre-existing conditions are now off the table? Because that means if you've had COVID and got over it, and thank God that you survived, now that could be a pre-existing condition. Now pregnancy can now be a pre-existing condition. All of these things that were pre-existing conditions that allow insurance companies to make premiums so much higher under the whole guise or auspices of you have a pre-existing condition, that therefore it's going to cost you more to have this in this particular coverage. So those are the things that we have to be concerned about. So as we wrap up, so now what do we do? Yes, some of you all said it's the year of horror. Yes, 2020 is the worst. But at this point, y'all, we do not have time to be wallowing in that. We have to figure out what it is that we're going to do on a local level and beyond, because we have an election coming up in 40 days. I cannot stress it enough, as I have with up and down the ballot. North Carolina, which I learned, has the 9th longest ballot in the country, y'all. The 9th longest ballot. Justice Beasley let us know that about a week or so ago. So literally, you have to have stamina when you are voting. If you have not obtained your absentee ballot and you are planning to vote in person, it's a long ballot from top to bottom. You can't forget the judges. You definitely have to go to the bottom of the ballot. It's our district court judges that are going to be at the bottom of the ballot that are going to affect the lives of everyday people. It's in your state, in your city or county officials that's going to affect you in terms of whether it's local ordinances. City council's not up, but county commission is up in terms of, funding and all of that. Obviously, your state senators and going forward. So it's so important that we are voting from top to bottom. As I've always said, iwillvote.com is your one-stop shop if you haven't registered. One thing that I know that, Rob and I preach, but it's very, very important. Please get this information out here. A lot of people in North Carolina assume if I have a felony, I can't vote. That's not true. If you have had a felony and you have served your time and you are no longer on probation or parole, your rights are reinstated. You just have to go register. I cannot stress that enough. Please help us get that information out there. All you have to do is register. As long as you're no longer on probation or parole, your rights are automatically restored. You don't have to do anything. Federal cases, you do have to go through a restoration process. You can do that at the clerk's office, and you still have time to do that. We still have one-stop registration, so you can also go, even if you can go and register and you can vote during early voting. We still have that. No, you don't have to have an ID. People are still spreading that misinformation. Dwayne, that's also a good suggestion. Also, make sure that you get a sample ballot before you vote so that you can be informed. You don't want to rely on whoever's giving you a palm card and whoever's smiling with a t-shirt on. That's great. You won't have time for that. We got to make informed decisions. And so definitely make sure that you are also, if you're in North Carolina, this is some of you all I know are tuning in from other states, but in North Carolina, you can go to the North Carolina State Board of Elections, ncsbe.gov, and you can get your sample ballot there. I Will Vote will get you registered. I Will Vote will show you your registration. Is it current? Will allow you to register, make changes. Will show you who your district rep is, who your senators are, show you all that good stuff. But as far as your sample ballot, you're going to either have to get that locally at MECBO, if you're in Mecklenburg County, meckboe.org, or you can go to the State Board of Elections website, get your sample ballot there. That's excellent, Dwayne, because please don't just pop up. You have plenty of time. We're in COVID. You don't have nothing better to do. Get your sample ballot. Look people up. Particularly people who are voting, that have voting records. Their voting records are available online. We have to do a better job of holding public officials accountable. We can't just vote R&D just because, obviously, in some cases, we need to vote D, but okay. But the whole issue is that you need to be an informed voter. Also, please do not listen to the man in the White House who repeatedly says you can vote twice. That is a lie, and it is a felony. Let me say that again. You cannot vote twice. So if you request your absentee ballot and you don't send it in, that's okay. You can't request your absentee ballot, send it in, and then go to early vote. You can't do that. It's a felony. You can't do that. What I do suggest for a lot of people, because I know there's a lot of concern about the post office and all that, get your absentee ballot, fill it out. Just take it to the Board of Elections yourself. Or if it's during early voting, you can actually take it and hand deliver it to an early voting location. If you have concerns, they could track you and let you know when they receive your ballot. There's a lot of mail that's floating around out there that may have information. If it doesn't come from your local Board of Elections or your state Board of Elections, just don't even deal with it. But you can request all of that online. You can request it by fax. There's any number of ways that you can request your absentee ballot if you prefer to vote absentee. But we have to come out in 2008 and 2012 numbers. Bottom line, we cannot leave any room for discussion. We can't leave any room for, gee, it's close. Ain't nobody got time for that. You need to vote. Everybody you know needs to vote, and we have to strategize. So, last word, Rob. Let's circle back, because I do want to know if there's anything else that you want to add in that regard, especially in dispelling some myths that people may have as far as the importance of this election. What would you tell to other men out there? Because a lot of the push is to make sure that we have a strong showing by Black men specifically. What do you say to Black men who are saying, this doesn't affect me, why should I care? My life isn't any better or any worse because of this. Why should I care? What would you say?
In that, although if your individual life isn't changed by what's going on, other people's lives have been changed, what's been going on, and that you can't complain if we don't at least get in and do the bare minimum. And the bare minimum is to be able to get there and vote either in person or by absentee ballot.
Okay. Excellent. And as we've circled back to the two topics, which was Breonna Taylor and the indictment, if you missed that part, definitely go back, because the replay will be available if you're catching the replay, but you can always catch the replay if you caught that, because we covered a lot of information. But what else, if anything, would you say to people who are struggling emotionally with this decision? Because it's traumatic. I mean, it's trauma all over again, feeling like here's just another situation where justice wasn't served. What would you say to somebody who's struggling with that?
Oh, that those feelings are valid, and that people should be able to embrace that and should be able to share that, and that we all don't have to have the same opinion or come down the same way. I have colleagues who are the complete opposite in terms of how I have, looked at this case, and they have like completely different viewpoints. But just like when we're talking about with voting, people, if you have concerns, as you should, but you have concerns about the criminal justice system, this is where we talk about in terms of how it is important to be involved, is important to vet, or is important to know who are those people making the decision, because those are people making the decision are the ones that are deciding in terms of which cases get prosecuted and which don't, because that goes back to that discretion. And then the last point is, I always like to say, jury service. We haven't had jury trials in North Carolina since March, but they'll be starting back maybe before the end of November or 2021. But when you get that notice and you make sure that you are safe and you feel comfortable being in that environment, but outside of that, then serve on your jury. That's how you can see in terms of what's happening and making sure that people are treated fairly.
Absolutely. Thank you, Rob, so much for joining me again tonight. So if you are not following Rob on Instagram, make sure you follow him at Robert Corbett ESQ, and the Corbett Law. Is it the Corbett Law Firm? I forgot that handle.
Yeah,
Corbett Law Firm. Drop your number. What's your number, sir?
That'll be 704-401-5299. 704-401-5299.
You gotta say it one more time. You gotta say it 3 times for people.
Oh, that's right. No, rules of threes. 704-401-5299. And that's you call me if Miss Trotman is too busy.
I'll take that shout out all day long. Thank you, sir. So for next week, for those of you, and we're going to flip the script back again. We're going back to the evolution, and we're going to have some church up in here. I'm so excited about my guest, national recording artist, Melvin Crispell III. You will remember him as being the winner of Sunday Best in 2019. He's joining me for a one-on-one conversation. We'll be talking about the evolution of gospel. We're going to have an amazing, amazing time. So make sure you join us here next Wednesday live here on The Conversation. Of course, as always, if you have not already done so, make sure you like, follow, and subscribe at all things at The Convo Pod Show. Excellent questions tonight, guys. I appreciate you chiming in with your questions. I hope we were able to get to your questions. You can always drop them in the comments later. And of course, if you're catching this on a replay, make sure you definitely catch us back at the beginning, as we had a great conversation on Breonna Taylor. And of course, make sure that you share this as well, as either as a watch party, or share it so that people can also get this information as well, because we've got to address the legal issues. We also have to acknowledge how we feel, but we also have to take action. And there's plenty of things that we can do now, is starting with making sure that we vote to take action. And we'll be exploring that after we make the changes that we absolutely need to make on November the 3rd. So everybody stay safe. I will see you next Wednesday. Thank you for tuning in. Thank you for chiming in, and have an amazing, amazing rest of the week. Y'all take care.